All right, everyone. Hello.
Morning, Professor.
Hi. Morning. You done? Okay, thanks. Call him back. Okay. Welcome back, everyone. I hope everyone's doing well. I hope everyone's staying warm. Let's see. So, any questions before we get started? Anything in your minds? Okay. So tomorrow, I have some interesting news. I'm actually testifying before Congress tomorrow. I'll be testifying for the House Judiciary Committee on the constitutionality of DAPA. So when I tell you that you are ahead of the curve, I mean that quite literally. So the way this works is that the House of Representatives has various committees that do all different things, and the Judiciary Committee talks about constitutional things. So they're having a hearing tomorrow on the decision on DAPA and the constitutionality. So they invited me, the Attorney General of Nevada, one of the law professor for the majority, and then the minority party has another law professor. So we'll be duking that tomorrow. It'll be at 10 a.m. I don't know if it'll be live, but it'll be on C-SPAN at some point, and you can watch it. Maybe I'll show the video on Thursday. The way it works is very odd. So I give a 5-minute opening statement where they can't interrupt me, and then they ask questions for 3 hours. So it's like your worst moot court dream come true. And they ask some questions. So there are 4 witnesses, and each witness gets, I don't know how many questions. It's about a 3.5-hour hearing. So I don't know what they're going to ask me. Half of them aren't even lawyers, and maybe they have some interests that are not legal, and I'll do my best to answer them. But you have learned virtually all the things which you would need to have this hearing, so you'll be well ahead of the curve. So after class today, I'm heading to the airport. I'll be back Wednesday night, and in time to teach you Thursday morning. You guys have no idea how many flights I take to get here on time, but haven't missed it yet. Anyway, so it should be on C-SPAN tomorrow. I don't know if it'll be live, but it's going to be on at 10, so you can check tomorrow and see what's going on. I'm excited, nervous. It's a very different audience than arguing to a court or arguing to other students, because these people have very different motivations. They're politicians. They have different things they want to get out. So I will do my best and represent South Texas well. All right. So any other thoughts?
How do you figure out who's on the Judiciary Committee? Just Google it?
Yeah, if you go to the House Judiciary Committee, you can see the members. There's actually several members from Texas. Louis Gohmert, Ted Poe, maybe 1 or 2 others. There's actually a number of Texas ones. Okay. All right. Let's see. All right. Any other questions? So if you want to see me getting grilled, a little Schadenfreude, right? Turn the tables a bit. You are welcome to do so. Okay. Let's talk about taxing. Yeah. That's what taxing power. All right. So in our last class, we have been talking about the Commerce Clause. And the Commerce Clause has taken some of a roller coaster ride throughout American history. And it started off as a way to prevent states from burdening other states. This was Gibbons versus Ogden. And then it shifted to limitations on the federal government's ability to regulate intrastate commerce, that is, commerce in one state, right? These are all the cases about, they can regulate the channels, the instrumentalities, the activities, but they can't just regulate wholly intrastate activity. But then we get to the New Deal cases. And the New Deal cases, the court basically said, whatever, right? We have a robust, growing national economy. We can't be hampered by these formalistic rules. If Congress wants to regulate wheat that never leaves a farm in Wickard v. Filburn, they can do that. Why? Because in the aggregate, if everyone starts growing wheat, it'll have a substantial effect in interstate commerce. Can Congress regulate marijuana that never leaves the state? Even though there is no marijuana market, the Supreme Court said yes, because it has a substantial effect on interstate drug market, whatever that may be. Okay? So for much of American history, the commerce power simply wasn't available as a means of regulating conduct, because it was only limited to things that were between states. That changed after the New Deal, but for much of American history, this power wasn't available. But what power was available throughout most of American history to regulate conduct in the states? And the answer is the taxing power. From the very beginning of this class, I think we've recognized that the taxing power was very significant. I think in the second week of class, we did McCulloch v. Maryland. This was a case where the state of Maryland tried to put a tax on the Bank of the United States. They tried to put a tax on the banknotes. And in that case, Chief Justice Marshall wrote, very famously, the power to tax is the power to destroy. And Marshall made clear if the states can tax these federal banks, then they can basically put them out of business. Okay? But that was the states taxing the federal government. What about the other way around? What about the federal government taxing the states and the people in the states? Okay? So our topic for today focuses on the taxing power, and we want to specifically answer the question, can Congress tax something, right? Is Congress doing this to raise revenues? Is Congress using these taxes to regulate conduct? So even though the Supreme Court has somewhat narrowed, right, the commerce power, the pre-New Deal cases regarding taxing power still exist. And this is one thing that frustrates students and law professors, I may add. Most law professors simply assume, oh, with the New Deal, they got rid of all those old Commerce Clause cases and all those old Taxing Clause cases, right? Not so. The Supreme Court's never repudiated the pre-New Deal tax cases, and we will see this very clearly on Thursday when we discuss the Obamacare decision. And in case you couldn't tell, the past 3 or 4 classes have been building up to Obamacare. I don't say this because I'm obsessed with the case, which unfortunately I am. I say this because this case encapsulates, as a summary, every aspect of constitutional law: Commerce Clause, necessary and proper, taxing power, spending power, okay? Everything is in there. So in order for you to get the Obamacare case, you really need each of the last 3 or 4 classes to build up to it. Right? That's why I gave more reading than I would have liked to for today, because otherwise Obamacare won't make sense. Comprende? Okay. All right, let's get started. I don't remember where we were. I'm sorry, I lost count. Does anyone remember where we? Thank you. I appreciate your honesty. Not in every class are people honest about this. Sometimes people just lie and everyone sits with their hands on their hands. You know, they don't want. No one wants to raise their hand. Actually, it was funny today. I was in the elevator going up, and there was some student. I don't know who he was. I was like, "Oh, how's it going? How's it going?" I was like, "Yeah, where are you going?" He said, "Oh, I'm going to ConLaw." I bet you. He was like, "Yeah, me too." So I love trolling. Okay, it's fun. I didn't ask him who he had because I knew where that one was going. He's not in this class. Okay, so Michelle, thank you. I'll start you off with a question we discussed already. But why is this power to tax the power to destroy? Why is this taxation power so important, so significant? And I want to frame your question. Put yourself back in the 1800s. Forget about all the Commerce Clause regulation, everything that came in the 20th century, in the 1800s, right? Why is this power to tax so important?
Because under the power of the king, he almost destroyed. I guess that's why the colonists came to America in the first place.
Mm-hmm.
They wanted to make sure that it was something, I guess, that didn't overpower the people to just take all their money.
Yeah, what's the impact of the king taxing tea, for example, right? We fought a revolution over tax on tea, right? What is the significance of a tax on tea? Why is that so significant when this tax is in place?
It was, I guess it was expensive. It was giving more money to the monarchy whenever it needed to spend it.
But what's the impact of putting a tax on something? What are people going to do less of?
Buy things.
Okay, here we go. Right? I know this sounds obvious, but I will make the point clearly. When you tax something, people buy less of it. Right? Taxing isn't only a means of raising revenue. Right? We all see cigarette taxes, right? Liquor I'm thinking Wickard. Liquor taxes, right? Sure, the government wants to raise money, but in theory, at least, these taxes are there to discourage behavior. So the government couldn't pass a law saying, well, you know what? You can only buy 5 packs of cigarettes a month, right? They couldn't pass a law saying you can only buy, you know, so many bottles of alcohol a week, right? But they can tax you. And they say, okay, sure, you want to buy a pack of cigarettes? Go put a $6 tax on it. I don't know what the cost is, right? But go put some significant tax on a pack of cigarettes, right? Right? I was going this way. So, Maria, so going back to 1800s, right? Say Congress doesn't like lottery tickets, right? They think they're very sinful. Could Congress have passed a law prohibiting the sale of lottery tickets back in the 1800s? Louder, I can't hear you.
No.
No, that's right. Why could Congress not ban the sale of lottery tickets back in the 1800s? Not today. Exactly. Is buying a lottery ticket in, say, Texas or Virginia interstate commerce? That's correct, right? So simply buying a lottery ticket, Congress could not prohibit that. But in the first case, it's mentioned in a brief note called the license tax case from 1866, right? Congress couldn't ban the sale of lottery tickets, but instead, what do? They tax it, right? Congress couldn't ban something, but they tax the sale of it. Okay?
Yeah, I'm just trying to get the
Okay. Yeah, pass it this way, please, when it's done. Thank you. I love the hand signals. So no, that's okay. You need like air traffic control, right? So Congress couldn't ban lottery tickets, but they can tax them. And this is a very powerful attribute of federal power, right? Even though Congress can't regulate conduct, they can simply tax it out of existence.
I might be going off base here a little bit, but is that kind of analogous to Louisiana when they held out on the drinking age? The federal government withheld the highway funds from them.
That
forced them into the.
That's South Dakota v. Dole, right?
Yeah.
So we'll get there like in 30 minutes. I promise. All right. Okay. So we have a lot of these early cases in the 1800s where Congress isn't actually regulating activity; they're just taxing it to submission. They're saying, okay, we can't tell you not to do something, but we'll make you pay a significant cost for doing it, right? But Adela, what's the downside of imposing taxes? And here, give me a little bit of a political answer, right? Why is it that politicians, like the people I'll be testifying for tomorrow, never want to be on record as imposing taxes? What's the reason why? The answer is obvious, right?
Because that will make them unpopular and they won't get.
Good, right? No one wants to raise taxes. Famously, President George H.W. Bush made a pledge: no new taxes. Ever remember that? And then he went and raised taxes, right? Or President Obama saying Obamacare is not a tax increase, and then he went to the court saying, oh yeah, it's a tax increase, right? Politicians do not like imposing taxes on people because they're unpopular, right? When there's a tax, it's very clearly you had some money in your wallet and now you don't, right? But in contrast, a regulation is invisible, right? A regulation is invisible. If there's some federal law that tells Farmer Filburn not to grow so much wheat, and that jacks up the cost of your bread, you don't know why the cost of your bread's increased. That cost is hidden. So the costs of regulation are invisible. The cost of taxes, you see it. It comes right off your paycheck. There's a line on it, right? When you go to the store, it prints on your receipt the purchase price and then the sales tax. In fact, about a couple of years ago, the federal government required airlines that when they calculate the price of a ticket, they have to include the taxes. This is evil. You don't even realize why, right? Now, you don't even see how much for your airline ticket's going to taxes. It's just built into the price. It's invisible. I like taxes to be very visible, so we know they're there so we can complain about them. Anyway. But there's a serious divide between the ability of Congress to regulate stuff and the ability of Congress to tax stuff. The taxing power is broader, right? It's much broader, but it comes with a political check. Any politician that raises taxes will suffer at the ballot box. Everyone get that much so far? Okay. This will come back to haunt us when we do the Obamacare decision, because the decision of the government to not call it a tax when it was being passed nearly proved fatal. We'll come back to this. All right, so let's go back now. We go to Article 1, Section 8. Okay. This is what's often caused. Did everyone sign the sheet? Do you need it? Anybody need it? Okay. This goes to Article 1, Section 8. It's often called the taxing power. And it says in the very beginning, Congress shall have the power to lay and collect taxes, to pay and provide for the common defense and general welfare. Okay? So let's think about this for a second. We said before in Article 1, Section 1, all legislative powers herein granted, right? The only things Congress can do are those enumerated in the Constitution. Then we have this language, right? Congress can lay and collect taxes and pay for the general welfare. So there's a question, a debate between James Madison and Alexander Hamilton, two very respected founders of this Constitution. What are the things that Congress can tax and spend for? Whitney, what are the things that Congress can only tax and spend for? Can they spend for anything? No, not done. Not done. Let me ask a question. But I appreciate the enthusiasm, right? Can they spend on anything? The general welfare of the defense? Can they only spend on those things listed in the Constitution? What is the extent of Congress's ability to tax and spend money?
I would say things that fall under that but don't get excluded by Article 1, Section 9.
What do you mean Article 1, Section 9?
The further limitations that they placed on it.
That's an interesting thought. Not exactly what I was thinking, but that's interesting. You're on the right track. Tiffany, what do you think? How do we read this? Are there limits on what Congress can tax and spend for? What are those limits?
They can only tax on the things that the states can't.
Interesting. So I think, okay, so explain more. What happens if a state can impose a tax on something?
And the federal government can't tax.
And where do we get this from? Where do we get this from? I think you said something. Yeah, and where's the separation of powers clause in the Constitution? Oh. Is there a separation of powers clause? No, there isn't. So I'm glad you said that, okay? So one of the interesting things about today's topic is the fact that there is no specific clause in the Constitution about the separation of powers, right? We have a 10th Amendment, which we've discussed before, right? We have a 10th Amendment, which we've discussed before. But the 10th Amendment doesn't say separation of powers. Rather, we look to the history of the Constitution and things like the Federalists and the courts said that these give us these principles that separation of powers are essential to preserve freedom, right? But that only answers a question partially. What are the limits, Jocelyn, on what Congress can tax and spend on? What are these limits? Okay, tell me more. What are the different views?
With Hamilton, there were no, other than they could, whatever they spend on the general welfare.
Yes, exactly. Okay, I'll come back to you in a second. But the Hamiltonian view, right? The Hamilton view was that Congress could spend money whatever damn well pleases. Anything in this broad umbrella, general welfare, common defense, Congress could spend money on. Right? Hamilton didn't see the Constitution as a limit on what Congress can spend money on. Okay, Johnson, what was the other view? I cut you off prematurely.
Madison,
Okay, what did Madison say?
he said that they could only spend money and tax on stuff that was in the
Exactly right. Madison said that they could only spend money on those things listed, enumerated in Article 1, Section 8. Remember, building post offices, raising armies and navies, punishing pirates, all those fun things, right? Madison said there are limits on only what the federal government can do. Right? But this raises a question, right? Who won out? So what we'll see is that ultimately Hamilton won the day. He usually did. You may recall another debate on necessary and proper, right? Madison said necessary and proper means strictly necessary, right? Congress can only do that which is absolutely necessary to get something done. What did Hamilton say? Congress do whatever is convenient to executing their powers. So here again, Hamilton's won out on the major constitutional debates of our day. He was fairly influential, even though Madison's often described as a father. Hamilton's won out in several of the biggest debates. But the ghost of Madison, like the ghost of Christmas past, right, survives. Because I think Tiffany alluded to this before, but Stephanie, what limits exist in the cases that we study today? New York and South Dakota, on the spending power. What are those limits?
I guess the 10th Amendment. Like, so if the state has the power to tax, then something.
You're right with the 10th Amendment.
Right.
Well, flesh that out a little bit more.
Well, you can't take the state's autonomy away
Good. Why?
because that's a built-in check in the Constitution.
Okay. Very good. Very good. The limit, for our purposes, right? The limit on the spending power and the taxing power is the separation of powers. That's not what you want. You're typing, you're ready for something good, right? But we'll go through this detail in these cases. The limits on the spending and the taxing power is that you can't intrude on state sovereignty, right? In the South Dakota case, you can't force South Dakota, you can't coerce them to change your drinking age. In the case of New York versus United States, right, you can't coerce the states to take title of radioactive waste, okay? Even though they adopted the Hamiltonian view with this broad notion of general defense or common defense and general welfare, in the background, lurking, is still this principle that you can't intrude on state sovereignty through the spending power. You can't do it through the commerce power, and you can't do it through the spending power. These are independent limits. Okay?
Can you say that one more time? The limits on taxing power cannot work.
To remember it. The limit on the taxing and spending power are the attributes of federal sovereignty, or the attributes of state sovereignty, right? Congress can intrude on state autonomy through the spending power. It also can't do it through the commerce power. There are limits from federalism imposed on this. See, it's tricky when people ask me to repeat something because it's like a minute-long block, and there isn't like a 5-second soundbite. The gist is the entirety of what I'm saying is relevant. I don't mean to criticize, but it's often difficult to try and recapsulate. That's why these horn books are not very good, because they try and distill like an hour lecture into a 3-sentence bite, and they miss a lot. So generally, the answer is to repeat is to, it's generally what I said, but I will try my best if it's not clear to restate it. Okay? All right. So questions on that? So we see today in the cases, right? Even though we have these pre-New Deal situations, these pre-New Deal cases, where the court found, limits on the tax and spending power, those survived the New Deal. And I want you to remember that because it's going to happen on the exam. Someone will say, oh, all these old pre-New Deal cases aren't good law anymore. They are. They're still good law. So let's talk for a minute about Bailey versus Drexel Furniture. Okay, this was often called the child labor tax case. This is actually, I found a picture of the Drexel Furniture Company in Drexel, North Carolina. And this was a factory that employed child labor. So you may remember in another case called Hammer versus Dagenhart. Right? Hammer versus Dagenhart. Congress tried to ban child labor through the Commerce Power. This was a 1918 decision. Okay? Supreme Court said, no, you can't ban child labor through the Commerce Clause. Why? Because it's not interstate commerce. Child labor in one state is production, manufacturing. Manufacturing is not commerce. All right? Everyone get that? So Congress tried Plan B. They said, all right, we can't regulate interstate commerce, so let's tax it. And this is a divide. We can't get rid of child labor through interstate commerce, so let's try and tax it. Let's put a 10% tax on any factory that uses child labor. Jason, how did the court handle that one in the Drexel case, the Bailey versus Drexel Furniture?
In the Bailey versus Drexel Furniture, they said that the child labor tax was not actually a tax.
Ah, wait, didn't Congress call it a tax?
Yeah, that's why they have it in parentheses. I was going to put air quotes up.
Right.
But they said that the sole purpose of taxes is to generate revenue for the government, and that Congress's motive behind its tax was to impose penalties upon businesses for employing children.
What is the difference, Jason, between a tax and a penalty? We'll do this in the next class. What's the difference between a tax and a penalty?
Well, I think we'll get to that in Dole, but I mean, the difference between a tax and a penalty, I mean, a lot of times they are synonymous because they hit you in your checkbook to penalize you, but then they also call it a tax.
Okay, good.
So, I mean, I'm having a hard time defining it, but I mean, yes, there is language that's different between a restriction or a penalty and a tax, but I think sometimes they can run kind of blend together.
That's good. Alejandro, let me ask you a related question. What is the constitutional difference between a tax and a penalty? The constitutional difference. This is a tricky one.
Well, Congress has the enumerated right to tax. It does not have the right to regulate, which would be a penalty.
Okay, that's good. Where does the power to tax come from, right? Where does the power to tax come from?
The Constitution.
More specific. Yeah, right there. If ever shows something on the board, the answer is there. That's usually the right answer, right? That's right. The power to tax comes from this, right? Alejandro, where does the power to impose penalties come from?
Doesn't really.
What's the best answer at where the Constitution gives Congress the power to impose penalties?
The necessary proper clause.
Yes. Yes. Attached to what, though? Necessary and proper attached to what? Which?
Congress?
Exactly, right? So here's the deal. There is no penalty clause in the Constitution, right? There's nothing in the Constitution giving Congress the power to impose penalties. But Congress can regulate commerce. And in order to make those regulations effective, Congress can impose a penalty. Let me say it again. In order to make their regulations on commerce effective, Congress can impose a penalty into the necessary and proper clause. Think about it. If Congress says we want to ban child labor, and today they could, but they weren't allowed to enforce it, right? Congress says, we're going to ban labor, but if you use child labor, we can't do anything about it. That's not a very effective regulation, is it? But they say, we're going to ban child labor and fine you $1 million if you use child labor. Okay, that will get their attention, right? That will get the attention of any factor that wants to use child labor. So you have to use a commerce clause and necessary and proper clause to impose a penalty. But for a tax, you only need that one clause. So we can generalize, right? The taxing power is much broader than the commerce power. The taxing power is a lot broader because you don't need to rely on necessary and proper in commerce, right? Those are fairly narrow bands. Even today, those are somewhat narrow. The taxing power can regulate entirely intrastate conduct. If you have a lottery ticket in a state that never crossed the state lines, Congress can tax it. No questions asked. They can't use the commerce power for that, but they can use the taxing power. Okay? So then the holding of the Drexel case is the Supreme Court saying, hey, wait a minute, you guys, you ain't fooling us. You ain't fooling us. We know what you're doing. This is actually a regulatory penalty. This is a regulation of commerce. But you're trying to hide it under the taxing power. No go. Not going to work. You cannot pretend that something is a tax when it's actually a penalty. Write that in your notes for the next class for Obamacare, right? You can't pretend something is a tax when it's actually a regulatory penalty. We'll see in the next class how the court handles that. But for now, that was a holding of the Drexel case. And by the way, Drexel's still good law. This flummoxed law professors. Law professors were irate. How can this child labor case still be good law? Well, it was never overturned. And it's still a valid principle, regardless of whether the child labor aspect was reversed. Okay. Okay, so the next, everyone, any questions on Drexel? Okay, the next case, and it's a brief case. They have an excerpt, which is the Social Security cases. There were two cases: Stewart Machine Company versus Davis. Look at that! Look at that factor. Look how strong they look. The Stewart Machine Company. And the second case is Helvering versus Davis. So I can tell you, this is actually a beautiful story. It's an awesome story. So during the New Deal, they were considering something that we now call Social Security, right? And I'm sure any of you have ever held a job know how Social Security works. It's a payroll tax. You ever gotten your pay stub, you notice SS, right, Social Security, and it takes a chunk out. What you probably don't know is that a certain other percentage that's paid by your employer, right? You pay some, your employer pays some, and that gets sent to some sort of lockbox in DC where the money's held for who knows what, right? Maybe when we're all 65, we'll get a paycheck. I doubt it. But in theory, at least, the money's being saved for us. Okay? The question, how can Congress make you pay this tax? Right? This isn't an income tax. The income tax is something entirely separate. So when the New Dealers were debating how to impose a Social Security, you know, the government was nervous, saying, oh man, look at this, right? The Supreme Court's been striking down all of our programs. How can we do this? And this is actually a true story. So Frances Perkins, who was a Secretary of Labor, she was a very prominent New Dealer, went to a tea party at the house of Justice Stone on the Supreme Court. And this is entirely inappropriate, but it happened. She admitted it. And so Justice Frances Perkins goes to Justice Stone, you know, Justice, we have this new program. We're very nervous about the court striking it down. This is the kind of stuff that happened in the New Deal. We have people in the executive branch asking advice of the Supreme Court. It's disgusting, but it happened, right? So Justice Stone says, come here, my dear. And he whispers in her ear, the taxing power is all you need. The taxing power is all you need. And shortly thereafter, the New Dealers changed course, and they said, Social Security tax. That's it, Eureka, right? So they said, we will impose a tax, right, on individuals. And what you have to remember about this case is it was a 1937 decision. And we've talked a lot about this magical year, 36-37, where the Supreme Court basically reversed course. And all the 5-4 decisions that were going against Roosevelt started going in his favor, with Justice Owen Roberts changing his decision. This was after the so-called court packing plan. Okay? And the Supreme Court upheld Social Security. But what you need to know about this one, right, is that this case, unlike others, didn't reverse the previous decisions. It left them intact. So we still have this distinction between taxes and penalties in our case books. Okay. All right. That's the taxing power. We will do more about this when we discuss Obamacare on Thursday. But that's all I want you to know about the taxing power for now. That as it stands now, there is a difference between a tax and a penalty, and Congress can't hide regulation in the taxing power. Any questions on that? Okay, very good. Let's move on, please, to the spending power. Okay. Sean, I'm going to ask you a trick question, okay? Where is the spending clause in the Constitution? It's a trick question.
I guess it's not there.
What do you mean it's not there? We haven't. It's in the book, spending power. Where is this spending clause in the Constitution? Where is it?
I guess it's corollary to Article 1, Section 8. If they have the ability to take in the money, then they obviously have the ability.
Ooh, okay. So now you let 3 questions have, but that's good, right? There is no spending power in the Constitution. There's no clause that says Congress can spend money on X, right? Let's read the text carefully. It says Congress shall have the power to lay and collect taxes, to pay the debts, and provide for the common defense and general welfare. Okay? So what does it actually say Congress can do? They can pay debts, right? And provide for the common defense. Sean, does it say anything about where Congress can spend its money?
Well, presumably it would be to pay for defense and general welfare.
Pay whom? Oh. How does Congress going about providing for the welfare and common defense, all that good stuff? How can they do that? Oh. What do you think, Nephi? How can Congress go about providing for the common defense and general welfare? What do it means Congress can do that?
By collecting tax, by taxing people.
Well, that's what they get the money for it. But how do they go about actually doing it?
Proposing laws, creating laws to basically get themselves out of the tax.
Does creating a law require spending money? Beyond salaries of members of Congress and stuff like that. So how does Congress get stuff done through spending money? What do you think? How does Congress get stuff done by spending money? Nephi's absolutely correct. They can pass laws, right? They can say do this or don't do this. Maybe they have a police department to enforce it, right? But how does Congress get stuff done by spending money?
They could hire private individuals to do jobs that they feel are necessary for the common defense and welfare.
Okay, so that's a good idea. So say Congress passes a law, Nephi?
Is it by using the money as incentives?
Ah, that's where I was going with this. Okay, explain more.
For example, like highways.
Ah.
In order for a state to have funding for highways, they must follow certain regulations that the federal government.
Very good. Incentives. Everyone know what I'm saying. There's no such thing as a free lunch. Everyone's heard that expression? If anyone ever wants to buy you lunch, they want something from you. I mean, even if they're your friend, they want your company, right? But generally speaking, we're all rationally self-interested. When someone takes you out to lunch, they want something from you. It's maybe I've been out of DC for too long, going back there tomorrow, but that's generally how things work, right? They want something. So, yeah.
I missed what the answer was, but like in the beginning of this semester, didn't he talk about so Congress makes a law or whatever in order to execute the law, things have to be done to get that law to work.
Right.
So isn't that just inherently
That's right.
Right. Okay, sorry.
That was my third answer.
Okay.
So you were 2 questions. No, but it's good when you anticipate where I'm going. There's a flow, I promise. So how can Congress get stuff done? They can pass laws, but how do they make sure that their laws are enforced? They can hire people, right? If the United States wants to have a bank in the United States, they hire a clerk to work at the bank. Use the word inherent. I like that word, right? An inherent aspect of running a bank is that you need to have a clerk working the bank. This is often called the necessary and proper clause. In order to actually regulate commerce and have currency, you need to have someone working at the bank. Okay? So for the first, 100 or so years of a republic, virtually everything regarding the spending power was Congress spending money on its own employees. bank clerks, law enforcement, customs agents, post officers, right? People who work for the federal government. But another aspect of this is what happens when Congress wants the states to do stuff. When Congress wants the states to do stuff. Caleb, can Congress force the states to do stuff?
No.
What about the Supremacy Clause? Aren't all the laws of Congress the supreme law of the land? Why can't Congress just pass a law and make the state comply?
And some of the powers are with the state, and Congress can't do it, and they can just encourage the state to do it.
Well, let's say it's something within let's say it's something within Congress's powers. Let's take an easy one. Let's say that creating a national bank, for example, right? McCullough, the Supreme Court said that Congress has the power to create a national bank, right? So Congress creates a national bank and say, okay, states, you're required to give us employees to work in the bank. We don't want to send our people from Washington down to Georgia. It's really hot. So give us, 5 workers to work in our bank, and that'll be nice.
It's kind of like the case that you got today. I mean, it would make the states liable for the state's employees would essentially be working for the federal government, but would still make the states liable for it because it's their employees.
What do you mean liable? I think you're on the right track. What do you mean liable?
Well, they're acting, I guess, as an agent.
Ah.
In theory for the federal government, but they're still the state.
Okay, that's good, right? So, and we'll get to commandeering in a couple minutes, right? But the general idea is that Congress can't force the states to do stuff, but they can bribe them, right? It's like when you have a little kid and it's like, no, I don't want to go to my room. I'll give you some ice cream. Okay, right? So you can't physically, I mean, I guess you could, but you can't physically throw the child in the room. That would probably be very painful. But you give the kid some ice cream, right? And he'll take the ice cream and he'll go to his room and stop crying, in theory at least, right? It works very much the same way with Congress. Congress can't force recalcitrant states to do stuff for them, but to say, hey, state, Texas, old buddy, old pal, want some more money? You want some money to pay for your roads or your schools or your health care or your pension system or whatever it is? We'll give you this huge pile of money, which we don't actually have, it's all debt. We'll give you this money, right? But you're required now to comply with our conditions. There are strings, like a marionette, right? A puppet. There are strings attached to this money. And because there are strings attached to this money, there are limits on how you can use it. So I'll give you an example from Obamacare from next week, but to give you a preview. But something called Medicaid, right? I'm sure many of you are familiar with this. Medicaid is a federal-state partnership that provides health insurance to people below the poverty line, right? People at or below the poverty line. So the Affordable Care Act said, hey, wait a minute, I got an idea. There are a lot of poor people who are above the poverty line. They need health insurance too. So we're going to tell the states, instead of just giving people at the poverty line health insurance, we want you to give people who are at 133% of the poverty line health insurance. We want you to expand Medicaid. Okay? So one state, Arizona, raised its hand and said, hey, Obama, I like things the way they are, right? I don't want to expand Medicaid. Even though the federal government basically pays for it, this will impose various costs to my state that I don't want. Can I just keep the money you're giving me now and not just, don't take this new money? Right? Everyone get the idea? So what do you think the president said? No. If you don't take this new money, we'll take away all of your old money also, which will bankrupt the states. That was the issue in Obamacare, the spending part. If the states didn't take this new money for the expansion, they stood to lose their entire Medicaid budget, where millions of people would lose their insurance. So even though the feds were paying almost the entire cost of the expansion, like 90-something%, right? The states did not have a meaningful choice. And you'll read next week in class, or sorry, in the next class, why the Supreme Court found this objectionable. Okay, everyone with me so far? But that's something that happened now 3 years ago. Feels like forever, right? But for the longest time, it wasn't clear if there were any limits on the strings Congress can attach to federal money. All right, so any questions before we start? We're back to South Dakota v. Dole. Any questions before we start? All right. Brandon, can you tell me, please, the facts for South Dakota v. Dole? What was the issue there?
Yes, South Dakota was suing because they were about to have their transportation, like highway budget, reduced by 5%. They didn't comply with raising the drinking age to 21 because they had those at 19.
Very good. And actually, it wasn't a 19 drinking age. It was if you were 19, you could drink the low beer. Everyone know what that is? It's like 3% beer from Oklahoma. I think that's still a thing there. It's very low grade alcohol, 3.2%, whatever it is. So at the time, South Dakota and a number of states had kept their drinking age at 19 for this low beer. All right. So before we get too far into federalism, let's talk about an amendment which you probably never thought you'd have to study, which is the 21st Amendment. Okay? So the 18th Amendment was Prohibition. This amendment basically banned the importation and sale of any kind of intoxicating liquors. Ask yourself a question. If we needed a constitutional amendment, why did we not need one to ban drugs? Okay. The answer is the New Deal. But it's a worthwhile thought experiment. But anyway, thankfully, we repealed Prohibition. It was the only amendment other than the 13th to limit individual choice, and this was a bad one. Okay, we repealed Prohibition. But if we repealed Prohibition, why do we still have dry counties? Is anyone from a dry county? So how far do you have to drive to get alcohol? Just across the county line? 15 miles away? Do you know why dry counties still exist? This is a good exercise, right? So has anyone heard of the expression Baptists and bootleggers? And you know what that means? You're shaking your head? No. Baptists and bootleggers, right? Anyone know? So during Prohibition, who were the strongest supporters of Prohibition, right? The Baptists, because they had the religious conviction of no alcohol, right? Who are the second largest supporters of Prohibition? The bootleggers. Why are the bootleggers in favor of Prohibition? Jacks up the price. Because when there's Prohibition, you had all the bootleggers making the gin in their bathtubs, right? And selling it in these speakeasies. This is a very common economics concept, right? Whenever there's someone who wants to ban something, one group does it for morality, and the other group does it for profit, okay? The Baptists ban alcohol because it's immoral, and the bootleggers ban it because they're going to make a lot more money that way, right? There's an episode of The Simpsons where they ban alcohol in this town, and Mo, the barkeep, is like, I've never made so much money before since they banned alcohol, because you ban something, people want more of it. Anyway, Prohibition doesn't work. So the reason why we have dry counties today is that the next county over lobbies to keep it in place, right? If you have to drive 15 miles away, I guarantee you there's a liquor store right in the county line, and they sell a lot. Yeah, that liquor store owner is probably lobbying significantly to keep this ban in place. So anyway, that's why we have dry counties. But constitutionally, Section 2 of the 21st Amendment allows states to leave Prohibition in place. It says the transportation of intoxicating liquors in violation of the laws thereof is prohibited. What does that mean? If a state passes laws or a county passes laws banning alcohol, those are illegal, right? States retain the prerogative to have dry counties or a dry state. Maybe Utah just goes all in and just bans alcohol everywhere. That hasn't happened, but you do have a number of dry counties that exist in Texas and elsewhere. Okay. So the question here in South Dakota v. Dole is, can Congress spend this money with these conditions. All right, so I'll ask as a threshold question up top to Juan. Juan, could Congress have passed a law that says all states shall raise their drinking age of 21, period? That's the entire law. Could Congress have passed that law?
No,
How come?
because it encroaches the powers given to the states to regulate the drinking.
That's good, but before we even get to sovereignty, what enumerated power would Congress have to rely on there? Which enumerated power in Article 1, Section 8 does everything?
Power to tax.
No, there's no taxing. It says all states must raise the drinking age to 21, period. What do you think, Patrick? Mitchell, I'm sorry. No, there's no money being spent. All the law says is all states must raise the drinking age to 21, period. What enumerated power would Congress have to rely on there? Combined with? Commerce. Okay, I want you to make this point very clear in your notes. The necessary and proper clause doesn't stand by itself. A couple of you said that, so I want to make sure to correct that. The necessary and proper clause does not stand by itself. The necessary and proper clause is a means to implement some other enumerated power. Virtually every case, it's a commerce clause. If I ask you which power, the answer is commerce, right? Just if you don't know, say commerce. But, right, the drinking age by itself is not commerce, but it may have a substantial effect in interstate commerce, so you can use this necessary and proper clause to do other things. So in theory, at least, right, before we get to federalism, Congress could say, you know what, all this drinking is having an effect on drunk driving on the highways, so we want all the states to raise their drinking age to 21 using our commerce and necessary and proper powers, right? Brett, what's the problem with that argument, though? Juan already said it a minute ago, but what's the problem with relying on the commerce clause in this manner?
It's not directly affecting.
Let's assume it's affecting interstate commerce. People are driving the highways drunk and they're killing each other and that stuff. What's the federalism problem here? Of Congress requiring a state to raise its drinking age to 21.
It's interfering with the state's power to regulate the age.
What is that state power? What do we call that state power? You got it, William?
It's the police power?
Exactly. Police power. You go to the 10th Amendment, right? The powers not delegated to the United States, nor prohibited to it by the states, are reserved to the states. The police power is that reserved to the states. When we talk about state sovereignty or state authority, we're discussing the police power of the states to decide, well, maybe our kids at 19 are responsible, they can drink, or maybe they should drink at 15, or maybe they should be able to drive at 18, right? Because there's no power delegated to the Congress to set national drinking ages, that's not a power given to them. It's an implied power, maybe. That's not a power given to them. This is a power reserved to the states. Yes, Hector?
What vehicle or what procedure does the state have to prohibit the federal government?
Say that question again, please.
In other words, it says you can't, the feds don't have the power that are prohibited by it to the state. So,
Article 1, Section 9 lists a lot of things that the states can't do. Right? So this is only saying if there's something prohibited, remember this prohibited, that's Article 1, Section 9. For example, states can't enter into treaties, they can't form alliances, they can't keep navies, right? There's certain things states can't do, therefore that's outside the state police power. So check Article 1, Section 9. Good question. So everyone see what's going on here, right? Congress could not use its commerce powers to force a state to raise its age to 21 because that would intrude on the police power, the state sovereignty. So instead, Congress goes to Plan B, right? Luis, Ryan, what's Plan B? How does Congress try to nudge the states to raise drinking ages? Yep. Yeah, Luis?
Were you just withholding funds?
Exactly. Spending power. Exactly right. So Congress says, okay, we can't make you, right, change your drinking age. We can give you a helpful nudge, right? Everyone knows what I mean when I say nudge. It's not quite a shove, but you kind of like push someone in the right direction. This is the work of Cass Sunstein and others. You give someone a nudge. So they tell the states, okay, we've been giving you all these highway funds for all these years to build your beautiful highways in South Dakota. Well, we'll take some of those back. We'll take them back. We're going to stop spending. Know that nice bridge you want to repair? Yeah, you can't do that now, right? Know those potholes on that highway you want to fix? Yeah, those potholes are going to stay the same. If you go ahead and you raise your drinking age, oh, we'll give you that money. What I want you to get is that this wasn't only an instance of highway funds. There's billions of dollars states get from the federal government, and every penny of that comes with significant strings. And for states to comply with these funds basically dictates much of state policy. There's a lot of stuff states may want to do that they can't. This is actually one of the reasons why states don't want to expand Obamacare, the Medicaid expansion, because it limits how states can handle healthcare costs, because you have to comply with whatever the feds say. So it isn't just about keeping poor people in the gutter, as some people may suggest. There's actually significant limits on how how states can manage their insurance programs. Okay. So that's the question. Yes, sir.
I have a fun fact. If you ever go to Hawaii, they have interstate highways as well, but they're not connected to any other.
Yeah, isn't that something, huh?
One of the things is like the government gives them money, but they still require them to call them interstate highways, even though they don't connect themselves.
Yeah. Yeah, it's actually funny. I don't know if you've been following this, but President Obama is trying to figure out where to put his presidential library. And he doesn't want to put it in Hawaii because no one will ever go there. And he considers Chicago, which we spent most of his time, but apparently the University of Chicago messed up their bid, and they don't actually own the piece of land they submitted. So at this point, it looks like it'll be in Columbia, where he spent fairly little time in his life when he went to college. Anyway, but yeah, so highways, they're the interstate highways in Hawaii. I got a better one, right? There's oh God, where is it? There's some little island. I think it's owned by Ernest Hemingway or something. It's in Florida somewhere. And there are these dogs on this island, right? And these dogs have never left this island, and Congress has deemed fit to regulate these dogs. I might be getting the facts slightly wrong. There's some island, these little dogs or horses or some animal, and these animals have never left the island, and Congress has deemed fit to regulate those. Whatever, right? So the court in South Dakota v. Dole, and we'll go way back up top to Austin.
Yes, sir.
Yes, sir. So we have here in South Dakota v. Dole, Chief Justice Rehnquist. By the way, Rehnquist's opinions you'll like because they're always very clear to read. He makes things very clear. He numbers stuff. He's very deliberate, which his writing style is good for students. Not always best for lawyers, but good for students. Austin, Justice Rehnquist finds 4 conditions, right, on the spending power. What are these 4 conditions on the spending power?
I've got the exercise between Congress being pursued of general welfare.
Okay, I'm going to stop you, but I'll come back to you in a second, okay? So Rehnquist says, listen, Congress has a spending power, and it's pretty broad, but there's some limits on it, right? So one of them is it has to be made pursuant to the general welfare. That you get from right here, right? First, you have to spend something involving the general welfare, right? Austin, is that broad or narrow? The notion of the general welfare.
It's pretty broad.
It's pretty broad, right? This is Hamilton. This is Hamilton. Madison said you can only spend on the things listed in Article 1, Section 8. Hamilton said, yeah, spend whatever you want, general welfare. Okay? Luke, what's the second thing that Justice Rehnquist looks at to see whether the spending clause is being adhered to? What does that mean? Who has to make what cut and dry? Congress. Give me an example. You use this case as an example, right? The highway funds case.
I guess with the drinking age and the funding for the highways, they're
raise the drinking age to 21, then we'll undo.
Exactly. Exactly. The second requirement is that the conditions must be unambiguous. Right? These can't be hidden choices. Congress can't pass like a million-page long statute and then bury in some minuscule clause, oh, by the way, if you don't do this, you may lose all this money. Right? This is actually a pending Supreme Court case involving this just now about Obamacare, because we argue next week. I'll be in D.C. for that also. Too much traveling. So the issue in this case is it has to be unambiguous. Congress can't hide these conditions. The states have to know what they're getting themselves into. The states know, if I do this, I'll get this money. If I don't, I won't. There's no wiggle room. There's no in between. What's this third factor, Shelby, which doesn't really mean too much? What does this mean, related? What does it mean, the third factor, that the spending must be related to the federal program? You use the drinking age as the example, right? How is the drinking age related to highway funds?
Driving across state lines.
Yeah, you're right. Keep going. It's exactly right. Who's driving across state lines? Exactly. So what happens if you have in one state the drinking age is 21, and right across the border the drinking age is 19, right? Everyone's going to drive across the border to get cheap booze. It's like if you go to the Northeast, fireworks stores, right? On the border of Pennsylvania, New York, or Pennsylvania, Maryland, there are fireworks stores right in the border. So people just cross over, buy fireworks, and come back. Because in New York, all types of explosives are illegal. So in other words, yes?
Is that what they were doing? Like in South Dakota, like I don't know much about South Dakota.
Neither do I.
It's like I feel like there's not much there. Like
Oh, what's so mean?
Like, I think,
Mount Rushmore.
Where are you gonna go? Like
Oh my God.
people are crossing this like state line.
That's terrible. I actually may be giving a talk there next month. I'll make sure to tell them my students think of South Dakota. People think the same of Texas, by the way, may I add, outside of the South. So,
Everything went like 15 minutes.
but Stephanie, let me ask you a serious question, though. Does Congress have to act with precision? Or can Congress regulate in broad generalities?
They can regulate in broad.
And that's actually, I'm very glad you said that. So this is the point that Justice O'Connor raised in dissent, saying, listen, this is stupid, right? The relationship between underage drinking and highways is very low. She said, if you actually want to get rid of this problem, you have to raise the drinking age to 30, right? Because there are plenty of people in their 20s who get into car accidents with DUIs. But the majority says Congress does not have to regulate precisely. They can do general swaths, right? If Congress can rationally conclude that raising the drinking age will decrease highway deaths, the court says they can do that. Stephanie, do they need a study or proof saying that if you raise the drinking age by 1 year, it will save X number of lives? Do they need anything like that?
I thought it like at least helps their case almost.
Does Congress need a strong case to win?
Not a strong case, but some kind of like evidence that they're
What was the holding in Lopez? I'll go back up top. Anyone? What was holding in Lopez? Does Congress need to have a clear link of how guns in school, harm education? What do they need? What's that word I'm looking for? Hook. They need a hook. All they need is some sort of stupid statement saying, we determined that guns in schools affect interstate commerce, makes education harder. Done. Boom. Regulation. We determined that based on some sort of study, does not even good, that there's at least one teenager crossing state lines to buy beer, and that's dangerous, and maybe he'll get into an accident, and then we can regulate it. This will frustrate people who like logic, but Congress doesn't need to act reasonably. I'll be there tomorrow. I will be a first-hand account of that. But Congress does not have to act rationally. They have to act rationally, but barely. Okay, they have some decent reason it's good enough. This is the point O'Connor raised, saying, listen, there's such a weak connection between raising the drinking age and highway safety, right? Maybe they can say you put more checkpoints through it, more DUI checkpoints. I don't know. There's something a little bit more closely related to this. You increase enforcement for underage drinking. But this is very weak. but the majority does not care. Okay. Any questions on that so far? What's the fourth one, Jonathan? What's the final countdown? The final limitation on the spending power?
Other constitutional provisions that bar it from being permitted.
Yes, right? The fourth one proves to be the most important one. The first three are basically automatic, right? Everything's in the general welfare, right? Everything relates to some sort of federal program, right? The first three categories are almost always going to be met. Those are easy. The fourth one's where the money is. Is there some sort of, quote, independent constitutional bar? Does the Constitution itself prohibit this? Right? So, Plowman, what are these independent constitutional bars?
For this particular case, I don't think there's one necessarily.
Well, what could the constitutional bars be? What's the topic of this entire class? What are the constitutional bars? What was the constitutional bar in the taxing cases before? What limits exist in the Constitution?
The inherent checks.
What do we call those? Separation of power. Why did separation of powers impose a check on the spending power? What is the problem here?
Well, there can be certain laws and different things passed by that, well, like the 21st Amendment right now,
Mm-hmm.
is a specific potential barrier to this.
Very good. Let's put aside the 21st Amendment for a moment, right? Beyond the 21st Amendment, what limits or why would this highway spending bill prove constitutionally problematic?
If it interfered with the relationship between the states and the federal government, as protected by the, like the dual sovereignty and all that.
Yes,
stuff.
exactly, right? We live in a system of dual sovereigns, right? We have two governments. No other country in the history of the world tried something like this. Some have tried since, but some haven't, right? We have two systems of government in our system. And they each have their own spheres. And we've quoted the 10th Amendment before. But the 10th Amendment means something, right? There's certain things that the federal government can do, and whatever they can't do, that's for the states to do alone. Things like the drinking age are aspects of the state police power. So while the federal government can give money to condition what the states can do, they cannot coerce the states. They cannot coerce the states. Right? And the court says, quote, at some point, pressure turns into compulsion. Pressure turns into compulsion. Michael, what does that mean, pressure turns into compulsion? Yeah, that's right. Elaborate.
Well, of course, the states
Is the state actually being forced, though? So that's the important part. Is the United States forcing South Dakota to take this money?
Well, no, it isn't.
But
in a sense it is, because without that money, the roads will be very lucky.
so what? So what? States can't raise their own roads? Believe it or not, before Hawaii had an interstate, I'm sure they had local roads, right? Why can't the states, Michael, just build their own damn roads? Okay, that's their problem. They can raise taxes. Why can't, right? Why can't a state build its own roads, right? I mean, why can't a state just decline the money and say, screw it, we'll build our own roads. We'll build our own schools, build our own, healthcare systems. We want no federal money, none. Texas just a script. We give it all back. Why can't the states just do that?
It wasn't budgeted, it wasn't planned, so by changing up the plan that the states have, then it forces them to, they've become accustomed to, I guess, the standard of living.
Yes, okay. Very good. Basically, for better or worse, the states are suckling at the teat of the federal government, right? And I use that image very deliberately, right? They do. They're an infant who needs the federal money because they're accustomed to it, right? Much like a baby needs its mother. But what if they suddenly start charging for that, right? They start decreasing the amount. What's the baby going to do? They're screwed. So the coercion doctrine is this bizarre doctrine that's emerged where states have become accustomed, dependent on a certain lifestyle, to use her phrase, right? And efforts to ratchet that back disrupt the federal-state relationship, right? Sam, could this possibly be right? That the federal government's decision to take money away violates federalism? Can this possibly be correct? Yeah. How can it be that the federal government's decision to spend less money is unconstitutional? How can it be? There's no obligation to spend in the first place. Where does this principle come from? There's a point made by the dissents, right? Where does this principle come from that states can't take money away? Where does this principle come from?
Tenth Amendment.
Where? Here, it's right on the screen. Where does it say the federal government can't take money away? It's right there. It's on the screen. Is it anything? What do you think, Haley? I'm sorry, Chloe. No? Why not? So where do we get this presumption that the federal government can't change the terms of the agreement in the middle of the road, like Debbie mentioned? Where does this come from? Want to give a step?
Uniformity throughout the United States.
Good guess, but that actually refers to taxing based on persons. That's not exactly, but I like your stab. Ian, you want to take a stab at it? Where do we get this principle from? Right? Where do we get this idea that taking money away from the states violates the separation of powers? Where is this coming from? Oh, I'm sorry, I said Ian in the back. I mean, Justice Rehnquist wrote the opinion. Justice O'Connor agreed with him in dissent about this, right? How do they build this case for this doctrine of coercion? Where does it come from? Ian. Connor?
I think from the Butler case.
Butler, okay, what did Butler say?
I mean, basically saying that the Agricultural Adjustment Act was unconstitutional because it was like the funding was more like a regulatory purpose than actual spending purpose.
But did Butler act on states or on individuals?
Well, I think it presumed it was off individuals.
Ah, right. But we have the question here. Very good point, Michael. It's a very good point about Butler. But I'm sorry, Connor. But the issue here is about states. Jacob, where do we get this principle that the federal government cannot spend money on states and then take it away when they don't like what's being done? Where's this principle come from? I'm sorry? Yeah, where's this doctrine of coercion come from? Where did the court get this from? Had there ever been an instance, Jacob, and the answer is no, but has there ever been an instance where the court has invalidated a federal state spending program? The answer is no. Has there happened? Why do you think there was never a court case where that happened? Why do you think states generally didn't complain when the federal government wanted to spend money? Christian, what do you think? Why do you think the states never really complain when the states want to hand out money? Free money, right? This is the rub. This is why the spending power is so darn effective. It's basically free money. Now, there's strings attached, don't get me wrong, right? But the federal government can say, look at this beautiful new highway we built. Not a single penny of Texas tax dollars were spent on it. You ever see those signs, like the National Reconstruction Act with Barack Obama, Joe Biden, like all these federal names on it, right? And all the mayor with her hard hat on, and everyone's all, digging the earth, right? No state dollars are put into this. Lies. All lies, right? Why? Because where did the money come from? The income tax, right? Who pays income tax? People and states. Now, it's not equally spread, right? You have some states that get more money than others. Texas actually gets quite a lot of federal money, contrary to what people in Austin may think. But various states get different amounts of pork and various federal monies. But it's invisible. No one says, oh, wow, I'm paying this money to the IRS, and look at this beautiful new highway connecting us to Austin or whatever, right? So there is no explicit coercion doctrine in the Constitution. And in many respects, the states go along with it, right? The states agree with this federal program because they get free money. But one of the aspects of the court's federalism doctrines is that states can't agree to a violation of the Constitution. We see this in the next case, the New York case. States cannot consent to a breakdown of the separation of powers. Grishma, why do you think states can't consent to break down the separation of powers? Why do you think this is a problem? Why does it not matter if states agree to a violation of the separation of powers? Why can't we just let the states do what they want? They want the money, let them have it. Maurice, what do you think? Why should it not matter if the states agree to the violation of separation of powers? Are the states getting more power this way? Who's calling the shots, Maurice? With respect to these highways, under what conditions does South Dakota get the money? Okay, so here's the issue, right? I think both of you are more or less on the right track. When the states surrender their sovereignty, when they give up this aspect of their sovereignty, they don't get it back, right? Once you relinquish this power, you don't get it back. So when the states give up the drinking age now to build the highways, what next? Maybe they have conditions on who gets a driver's license, right? You have to pass a federal exam. If you want those highway funds, you got to do it. And then maybe you have to raise the driving age to 18, even though maybe your state has no public transportation. You need people to drive under the age of 18, right? The point the court makes, and again, we can argue about this. It goes both ways. But the point the court makes is that the states can't be trusted to handle their own sovereignty. As perverse as that sounds, the states are intoxicated by federal money. The states are intoxicated by free stuff, like a little baby grabbing for a brass ring, and they can't be trusted. And the mere fact that states acquiesce to these violations of separation of powers is all the more reasons why the court should enforce it. I'll give you a contemporaneous example, which I'll have to talk about tomorrow. So with DAPA, the judge in Brownsville issued an injunction saying in all 50 states, there's no DAPA, you can't get it. 13 states said, we really want this. We want our immigrants to come out of the shadows and get these working papers and everything else. And the government argued, wait a minute, how can you tell the state of New York or the state of Washington, right, that wants DAPA that they can't have it? And I think the answer is states aren't trusted to acquiesce to separation of powers, that these separation of powers exist independently. I actually need to write this after class. I'm thinking out of my head, but that's what I'm going to say tomorrow in response to a question, right? States can't acquiesce in this manner. Okay? So we have the holding, right? Holding of South Dakota v. Dole. The 5% of the highway funds is not coercive. It's a fairly small amount. Justice O'Connor, in her dissent, makes the power, I think, fairly forcefully, that there are limits, that when something becomes coercive, it's unconstitutional. I should add that after South Dakota v. Dole was decided, was it 1987 or so, until 2012, so a 25-year period, from 87 to 2012, there was no Supreme Court case, none, finding a violation of spending clause. In the entire lead up to the Obamacare litigation, there were like a dozen court opinions by all different kinds of judges. Not a single judge at any juncture found a violation of the spending clause. The first judge in American history to find a violation of the spending clause was Chief Justice Roberts in the Obamacare decision. It was not until the Supreme Court handled it to find a spending clause violation. No one else found it. So this was a doctrine that until 2012 was very much in flux. I remember saying in law school saying, is there any violation of spending clause? The answer was no. Okay, well, now there's one you'll talk about in next class. But the important part is the Supreme Court found the Obamacare expansion of Medicaid coercive. Okay. Any questions so far? Yes, sir.
A quick question.
Yep.
It might sound a little silly, but why? What's preventing the state? Is it? Do they make a contract with the federal government? Like, can't they raise their age to 21 and then build the highways, get the funding, and then they pass another law to bring it back up?
You lose your funding. So the way appropriations work is renewed every 1 or 2 years, right? So they very well may get the money for year 1 and year 2, but then the year 3 they'll get canceled. Yeah, I mean they're welcome to then reverse their law and have the highway built. Like, haha, but most highways aren't built in a year. They take longer than that. So then they'll have like a half-built highway, bridge to nowhere, so to speak, right? Any questions? I have too much fun at 9 in the morning. Okay. Any questions on the Dole case? And by the way, in case you're wondering, the Dole in South Dakota v. Dole was Elizabeth Dole, who was a secretary of the Viagra spokesman, who was also a senator from Kansas. His name is Bob Dole. He ran for president in '96, and his wife was a secretary of transportation, I think. Okay. All right, let's talk about guns. Oh, no, let's talk about radiation. Sorry, we'll do guns later. Got ahead of myself. So the second case will be, the next case we're discussing is New York versus United States. The facts of this case are bizarrely complex and Byzantine, so I'll try to summarize them as best as I can, because most of the facts are not really relevant to what I want you to learn, although it's a very interesting scheme of laws. So we have low-level radioactive waste, right? We're not talking about like, Toxic Avenger or stuff that'll give you superpowers, right? We're talking very, very, very low-level stuff. If you ever look at your watch and like it glows in the dark, there's radioactive material in your watch which reacts to the darkness, right? If you ever have like a smoke detector, don't break that because there's basically some low-level radioactive waste in there which you use to determine any kind of fire or thing. So we have all this radioactive waste. It exists for a very long time, hundreds of years, and you can't really dump it in the trash or in the river because then you get Swamp Thing. It's really bad. So there are only 3 places in the United States in the 80s which were suitable for disposal of this low-level radioactive waste. So you can imagine the problem, right? All the states, all the companies that create this waste were dumping their crap in these 3 states, right? No one wanted it. Does any state want to build a radioactive waste dump in their backyard? Of course not. You've heard the expression, not in my backyard, right? NIMBY. No one wants to build a radioactive dump in their backyard. But there's a problem. What happens if these states stop accepting all this waste? They say, we can't accept it, we're full. We have an ecological hazard because you have all this waste and nowhere to put it. So Congress came up with the states with this very elaborate scheme. Okay? I don't want you to worry too much about the various details of it, but there were different aspects. So one aspect basically said states can come together and make agreements and they can exchange radioactive waste. These are called interstate compacts. And I mentioned this once before, but the general deal is if you have a driver's license in Louisiana and you cross over to Texas, your driver's license is valid, right? Why does Texas have to recognize a driver's license? Through something called an interstate compact. All the states agree to it and Congress approves it. Okay? What other aspect of these laws worked? Okay? So they have monetary incentive. They said if you build a radioactive dump and do these different things, the federal government will give you money. Okay? Is there any problem with that? No. Congress can spend their money however they want, and they can put conditions on it. Right? They also said that if you don't comply with whatever rules we're passing, we'll charge you more money to dump in these 3 states. Can Congress do that? Sure, that's a regulation of interstate commerce. What I want you to focus on is the 3rd provision of this law, which is called the take title provision. And what this 3rd provision said was that if a state doesn't actually build a place to dump all this waste, they must take ownership or take title of any radioactive waste created in the states. So if you have some sort of factory or chemical plant in Texas, and Texas doesn't build a radioactive dump, it's a state's problem. The state's liable for disposing of it, and oh, by the way, the state's liable for any damage caused by having this massive radioactive dump in your backyard. Okay, so here's the challenge, right? The states have 2 choices. They can either be forced to build a radioactive dump, or it can be forced to take ownership or take title of this waste and dump it somewhere. Okay? This is basically the choice presented to the states. All right? So, Brandon, what happened? What did the court do here?
They said that it was unconstitutional.
That's right. Why was this take title provision unconstitutional?
They kind of crossed over from encouraging states to the government and public policies to basically coercing or compelling, leaving them no other options but unconstitutional.
Exactly. They had no choices. The choices were twofold, right? On the one hand, they can build a radioactive dump. On the other hand, they'd be forced to accept this garbage and take responsibility for it. So let's break it down for a second. Morgan, could Congress have passed a law saying that all 50 states are required to build radioactive dumps? Could they have passed that statute?
No,
Why is the answer no? That's correct, but why is the answer no?
because we can get into the whole state rights.
Well, let's get into it. Why can Congress not do it? That's what I'm asking.
Because the states have the right to control and so if you're talking about.
But isn't radioactive waste interstate commerce? Isn't having this huge dump of waste going to substantially affect commerce in other states? So, but why can't Congress force a state to build a radioactive dump? I'll give you a hint. The answer is not commerce. Yes, sir.
Because Congress only governs people, not states.
Ooh, where do you get that from? He said Congress can only govern people, not states. Where's that from? Where in the Constitution? Where's the people clause? You're right. Let's go back to Lauren, right? Lauren, beyond the Commerce Clause, and he alluded to it, right? Why can't Congress require a state to build a garbage dump?
I would assume because they can't regulate what states are doing.
Why not?
Because that sovereignty is reserved to the state.
Good. Okay. The answer here is basically state sovereignty. What do I mean by that? The court in New York articulates what's come to be known as the commandeering principle. Commandeering, like to command, commandeering. What does that mean? The federal government cannot commandeer or command the states to do stuff at their bidding. Congress can regulate commerce. Congress can say, we're going to pass a federal statute, and that preempts all state law, right? So let me ask this question, right? Zachary, could Congress have passed a statute saying that all 50 states, if they have a nuclear dump, must follow these environmental standards how to dispose of the waste? Could they have done that? Could Congress have passed a single statute saying, we will decide all 50 states how environmental handling of this rule of this waste must provide? Why? Under Wickard and Katzenbach, why is that a stretch?
What's strictly forcing them to regulate the uniform regulation policy from 50 different states.
Have you heard the Environmental Protection Act?
Not recently.
Well, the answer is yes, right? I appreciate your instincts. Your instincts are probably right. But as a matter of course, we have environmental statutes. Yes. I'm getting there. I'm like 2 questions away. Building up to it, right? It's like building blocks, right? So if Congress wanted, they could pass a single environmental act that preempts state law. What do you mean by preempt? Say New York or Texas had some previous state law of handling this waste, that law is nullified. Under McCullough, if you have a state law that conflicts with the federal law, the federal clause wins out. So Congress could preempt all state law regarding nuclear waste disposal. But Gabrielle, can Congress make the states go ahead and actually build these disposal facilities?
I guess it technically can't make them, but if they were to tax it and say that you don't.
Ah, good. Okay, well, taxing is a good point. I wasn't going to go there, but that's a fair point. Congress could also, like Gabrielle said, what if Congress said any state that has this nuclear waste must pay a tax of $100 a pound or whatever it is, right? Could they do that, Gabrielle? Absolutely, right? So Congress can get rid of state law discussing radioactive waste. They can give the states money till they build it. They can even tax radioactive waste. What's the one thing they can't do, George? The one thing they can't do? Make you do it. You have to comply with federal law, but you don't have to execute it. This is the key point. If there's some sort of federal law, you have to comply with it. You have to pay a tax on it. If you take some money, you have to go along with it. But they can't make you do stuff. This is what's known as the commandeering doctrine. That the federal government cannot force states to build a nuclear waste dump. They can't do it, the court says. Okay. Questions on that? Now, the obvious question is, where does this come from in the Constitution, right? This is Justice Stevens's rally cry. He's still complaining about it 30 years later. He's like, I'm serious, he is. He's retired, still complaining about it. It's like, the commandeering doctrine, Justice Stevens says, is fiction. It's made up. It exists nowhere in the Constitution. There's a long history, right? There's a long history of the federal government telling states to do stuff. The majority, both in New York and in the next case, Printz replies, no, to the contrary. In virtually every case where state officers implemented federal law, it was a request, not a command. What's the difference, James, between the federal government asking a state to do something and telling a state to do something? What's the difference?
I guess asking would be, you can attach an incentive to it, and then telling you to do it is do this or.
Can states disregard federal law? Think of Cooper v. Aaron, where the governor was saying in the Little Rock High School blocking the access of the students entering, right? Can states ignore federal law? No, the answer is no. States, yeah, at least I think so. States can't ignore federal law, right? So the difference between a request and a command is that the request gives the states a choice. It respects their autonomy as separate sovereigns. They can say, well, maybe we'll do this, maybe we won't. But a command has to be complied with. And that's where a governor of a state says, all right, you guys elected me, I don't want to do this, but I'm being forced to. So in our system of dual sovereigns, the states cannot be commandeered or forced to do this. Right? The dissents make the point this is all made up. This comes from nowhere in the Constitution. Justice Stevens really has been rallying about this for 30 years. He'll keep doing so. All right, so any questions on New York? Now, yes? The commandeering doctrine is not written anywhere in the Constitution. This is what the Supreme Court has, inferred, gleaned, understood from our history and the framers' conception of dual sovereignty. But this is largely a doctrine that's hard to find in the text of the Constitution. This is one of the main points critics make of this doctrine. Yes, ma'am.
And I know the Supreme Court didn't uphold gay marriage bans in Florida and Alabama, so could they turn around and not hand out marriage license to same-sex?
Well, we discussed that 2 weeks ago, didn't we, when my dad was here? So the issue, and I discussed it before, but the issue in the Alabama and Florida case is slightly different because there the plaintiffs screwed up. They sued the wrong people.
But let's say they would have sued the correct people.
Well, if they sued the right people, then the people have been bound, right? If they had sued the correct officers, then they would have been bound by federal law. No state has, and I mean this sincerely, no state has actually flagrantly ignored the gay marriage rulings. It's just the Alabama, Florida people, they didn't follow the right case. Yes?
The issue where the government argues that public officials have agreed to this act, they support the act, and the court serves as a middleman and says it doesn't matter if the states are acting constitutionally.
Uh-huh.
Doesn't that take away the whole argument that we're trying to give state sovereignty in their opinions and what they agree upon? I don't really see how that's.
So are you saying that states should be allowed to consent to the violation of separation of powers?
Well, when you say it like that, it sounds.
Okay, I'll say it differently. So can states consent to being commandeered?
Well, no, but isn't that a fine line, commandeering versus persuasion? I mean, all of these cases are trying to find that middle ground, right? So it's up to the opinion of the court what's crossing the line either way.
So let me ask you this question. Who gets to decide where it crosses the line, the courts or the states?
The court.
So for better or worse in our system of government, the court's a final arbiter. And if the court finds a constitutional violation, your question is, can't the states consent to it? Right? Let's assume for a moment it's unconstitutional, right? I mean, and we can argue for the rest of the class whether the Supreme Court actually should be legitimately saying this. But does it matter if the states are acquiescing to what amounts to unconstitutional behavior?
Well, no, because we learned in the beginning of class it doesn't matter if the president acquiesces to overstepping in Congress. I mean, it's the same argument, right?
Why? But why is it important to preserve the separation of powers according to the Supreme Court? What does separation of powers ultimately protect? Individual and their liberty. This is the point the Supreme Court makes, which again, not everyone agrees with. The reason why we have the separation of powers and we separate sovereignty is to protect individual liberty, right? It may not be totally obvious why preventing New York from taking title to this radioactive dump infringes individual liberty. But this next case, ooh, perfect segue, right? This next case, I think, does show this, and I will walk through this one as well. So in the early 1990s, Congress passed the Brady Act, which had a lot of various gun control provisions. A circle footnote, in large measure, it was this act which is the reason why the Democrats lost the House in 1994. There was such a massive backlash by gun owners against this bill. But one aspect of the Brady Act imposed for the first time federal background checks. Now today, if you go and buy a gun in any store in Texas or elsewhere, you have to do an instant background check. It takes a couple minutes. It's very quick. You run your name, your birthday, whatever. It runs a background check. and it returns almost instantly yes or no. By the way, those records are not kept, which is a very important point. Back in the early 90s, that didn't exist. That technology simply didn't exist. So the federal government had this genius idea. It said, okay, I got an idea. If you want to buy a gun in Ravalli County, Montana, right, where there probably weren't any computers in the 1990s, we're going to tell the chief law enforcement officer. This is Sheriff J. Printz. I've actually emailed with the guy. And this is actually Sheriff Richard Mack, who was the other guy. There were two. He's actually very bitter that the case is called Printz for the United States. He actually sent me this email saying we should alphabetize it and make it Mack. But the rule is whoever files a petition first, and Printz was filed first. So a funny post on, he became a huge guy in the Bundy Ranch standoff last year. So he's been keeping busy. Printz is an NRA board member. Anyway, so this is the argument, Printz. Yeah, Sheriff Printz, he looks like a sheriff. I mean, the guy's built like an ox. He's huge. I love this picture of him saying for the Supreme Court and of him directing traffic in Ravalli County, Montana, right? So what did this law say, right? This guy, Sheriff Printz, the law enforcement officer, is required to run a background check based on his records of anyone who wants to buy a gun. And within 5 days, he's required to tell people, you know, yes or no. Okay? So what you should first know about this case is it wasn't about the Second Amendment directly. But this was a serious Second Amendment case because this would impose a nationwide background check and 5-day waiting period to buy a gun. Printz was actually a board member of the NRA, among other things. The areas with his NRA shirt. Okay? What did Printz say? He said, this is commandeering. You are forcing state officials to execute federal law. You are forcing state officials, a sheriff. He was actually the sheriff and coroner. Ravalli County was so small, he was a sheriff and coroner of this town, okay? Dead job, but it, you know, whatever. So he had this obligation. He challenged this lawsuit, bankrolled by the NRA, in federal court, saying that you cannot commandeer me. Again, New York was only commandeering of the states. This represented not telling Montana what to do, but telling Sheriff Printz what to do. Okay, so where was I up to? So, yeah, thank you, sir. Gabriel, let me ask you this question. Could Congress have authorized to put a FBI agent in every single county in the United States to sit there and anyone wants to buy a gun, you call this local FBI agent, he runs a background check, and in 5 days gives you an answer? Could Congress have done that?
No.
I'm sorry?
I said no, I wouldn't think so.
Why not?
Because it's, I guess, against what the framers and.
No. Could Congress have authorized the hiring of 1 million new FBI agents to put one in every county in the country? And if anyone wants to buy a gun, they have to, the gun store has to go to this FBI agent, run the paperwork, and approve in 5 days. Could Congress have done that? Why? Is there any constitutional problem there? What's the constitutional problem there? Yasmin? Is there any constitutional problem with the federal government using its own officers to implement this law? Louder? What problem could possibly exist with that? Good. Yeah. Look, they just implemented this new massive, gun control program, and in order to effectively keep guns out of dangerous people's hands, they're going to put a federal officer in every county in the country. He maybe wear a red coat. I don't know, and he can make sure that people get their background checks done in 5 days. But they didn't do that, right? Elliot, why didn't Congress put a federal agent in every single county, at every single gun store, waiting to run these background checks?
It's not really reasonable.
Why is it not reasonable?
The money aspect, I think.
It's expensive, but what else? What made the people, I'll go back up to this picture, what made the people in Ravalli County, Montana have done, I'm not being too facetious, if a federal agent was stationed in every county to check their gun records? What do you think would have happened, Elliot? Think of Bundy Ranch, right? I taught this last year when I was teaching ConLaw, but you have the Bureau of Land Management, which is basically telling these ranchers in Nevada what to do with their land. And people started, walking around with guns. Okay, and we can talk about this when we discuss the Second Amendment, which we'll do in the last class. But in one sense, it's more respectful of sovereignty to use local officers who know the people than to impose a federal agent in a county who doesn't know the people, right? Use this guy. Look, he knows everyone directing traffic. He's a cool guy, right? Interesting guy if you Google him. So they could have done that. But instead, they said, we're going to require the local law enforcement to run these background checks, right? Amanda, can Congress do this? What did the majority say about Justice Scalia?
They said that they couldn't do that.
They could not. Why?
Because I guess, they kind of like the previous case that we were talking about, they couldn't command state officials to essentially do what they wanted.
Okay, good. But let's see, Renee. But the last case was about commanding states, right? And we said that states have this, autonomy, these dual sovereigns. Here, they're not commanding the state; they're commanding Mr. Printz, Sheriff Printz. Didn't we say in the last case that Congress can regulate individuals? Why is this a problem? Why can't Congress regulate and command Mr. Printz to, run a background check? What's the aspect of federalism there? Why is federalism even implicated? He's not a state. He's a person. Ah.
They're enforcing federal law, which should be enforced by the executive.
Of the state, right? Mm-hmm. Okay, very good. So this is the move Scalia makes, and we can debate this. It's it's a little dubious, right? But we start off by saying that the states are sovereigns and the federal government can't commandeer them. Right? Jennifer. Who does Mr. Printz work for?
The state.
He works for the state. Who's his boss all the way up the chain in the executive branch? The governor, right? So Scalia says like this. This isn't really just regulating what a person does. This is setting state policy. Montana, as far as I know, had no background checks at the time. Or if they did, they were probably very light. Now, you're requiring a sheriff to implement a policy that a state did not enact. So it's not as simple as just telling him to go, if there is a crime, to transfer some evidence to a federal agent, right? You're telling him to implement a policy that's contrary to the policy of his state. But didn't we say, right, Mary, didn't we say that if Congress wanted, they can enact a nationwide gun control law? And forget the Second Amendment for a second. That Congress can create a nationwide gun law and preempt all state gun laws. Couldn't they do that? They could. But they didn't do that. They tried to take a less strict path by simply allowing state officers to implement this law. Scalia says no go. That it doesn't respect state autonomy by forcing these state officers to act. Okay? So we have this weird situation, right? Congress could, in theory, put aside the Second Amendment for a second, preempt all state gun control laws, making one set of gun control laws. Congress could give states money. Say, okay, if you want these highway funds, you need to impose the background checks. But what Congress cannot do is require the states or their officers to implement federal law. Everyone see that? Joe, what does Justice Stevens say in dissent? It's his rally cry. He's still screaming about it 20 years later.
Well, one thing that stood out to me was that it said we must consider its implications in times of national emergency.
Ooh, good. So, what happens during a time of war, right? There's a sudden attack, and the president says, we need troops now, I am going to direct every state governor to supply me with, 5,000 troops. We don't have time to hire federal draft officials. We don't have time to draft. State governors, you already have the implementation. Give me men, women, whatever, right? Could that happen?
Yes.
Is that commandeering? Crystal, you're shaking your head. Wait a minute, couldn't happen. So could you imagine during World War I, say that we surprise attack, right? President told the states, give me soldiers, and one state said, no, I'm going to sue you in federal court. How do you think that lawsuit would have gone? Say again? Thank you. Right. So I'm glad you said that. So Justice Stevens always tries to use this war example, but we've seen that during the times of war, laws often fall silent. And it's quite true that during a national emergency, I think it would be very unlikely for a state to sue in federal court over having to hand over, military officers, right? But Stevens' point is somewhat well taken, right? If there actually was an emergency and the federal government didn't have the manpower to have this implementation, they could request the state to do so. But the point that I think Scalia replies is these will be requests, not commands. Right? There's a big difference between requesting something and demanding it. Right? Like I can request that you come to class, I can't actually make you. Right? I can request you take the exam, I can't make you. I can flunk you if you don't. But I can't make you do anything. This is what professors often get frustrated by. I know I can't make you do anything. I can't. I lack the power to do so. The federal government, in contrast, can make you do stuff. Right? If Sheriff Printz did not comply with this, he probably could have been indicted on a federal offense. Right? He would have been fined, sent to jail. By the way, had this law gone into effect, there's absolutely no way this man would have ever turned down a single gun application. He wouldn't have complied with it. There would have been civil disobedience if this had happened. This is what people don't realize about the Brady Act. There's no way you have these small town sheriffs who have ever complied with it. It was not going to happen. Okay, so we have here these precedents, right? We have New York, which stands for the idea that the federal government can't commandeer to do. We have Printz, which stands for the idea that the federal government can't tell individual officers of the state what to do. And this provides a nice segue to our next class, which will be probably the more intense ones, which is discussion of Obamacare. Okay? Can Congress require individuals to buy insurance? This is not just a regulation of health insurance or a regulation of people who already have insurance. The question is, can Congress make you buy health insurance? Okay? Now, I may keep you a little bit late on Thursday because it's a fairly long lecture, so I'll just brace you for it in advance. If you need to go for class, whatever, just get up and go. But it may be a little bit longer than the usual one because it's a lot of material to cover. So I encourage you to read the entire case. I gave you an excerpt of the book I wrote on this, and you can watch me on C-SPAN tomorrow. All right. Have a wonderful day. Thank you.